A single mismanaged workers' compensation claim can easily lock away six figures in company cash reserves for years. For decades, many agents and employers operated under a rigid assumption. If an employee didn't suffer a physical trauma on the job, they couldn't claim a mental injury. New York enforced a strict physical-mental standard to back this up. If an incident lacked physical contact, a claim for workplace stress was guaranteed to be denied by the state. On January 1, 2025, the state legislature permanently eliminated that physical requirement. Today, any worker in the state can file a workers' compensation claim for anxiety, depression, or PTSD, post-traumatic stress disorder, without suffering a single physical scratch. This mandated complexity requires immediate operational awareness. Employers must adapt their reporting processes today, or they risk facing a $100,000 liability per claim tomorrow. Under the new law, purely mental claims are only valid if an employee proves the situation involved extraordinary stress. The law explicitly excludes the usual irritations to which all workers are subjected. Think of the baseline frustrations of daily life, like waiting in a long TSA, Transportation Security Administration, line at the airport, or receiving a speeding ticket. In the workplace, this baseline covers normal friction. A supervisor snapping at an employee over a high-pressure deadline is a usual irritation, and it does not qualify for compensation. The legal threshold separates everyday pressure from extraordinary stress. Events like witnessing a fatal warehouse accident or enduring a documented pattern of severe bullying. The Workers' Compensation Board, the state agency that processes and rules on these claims, evaluates these on a strictly case-by-case basis. They act as the judge, deciding exactly where a specific workplace event falls on this scale. The state will not force you to compensate workers for the normal friction of daily life. Mastering the exact legal boundary of extraordinary stress is your absolute first line of defense against frivolous claims. You have another specific legal protection available to block retaliatory stress claims: the Personnel Decision Shield. The law explicitly states that mental injuries are not compensable if they result from a lawful personnel decision made in good faith. This protects standard actions like job transfers, work evaluations, and layoffs. If you terminate an underperforming employee by following company policy and they file a stress claim the following morning, you must deny that claim immediately. Your secondary layer of defense is strict medical causality. Having a bad day at work does not constitute a legally valid mental injury claim. A licensed medical professional must diagnose the condition and establish a direct causal link between the workplace event and the injury. If the employee has a pre-existing history of mental health issues, your carrier must actively challenge the causality of the new claim. The state cannot penalize you for enforcing basic company standards. However, that protection only exists if you aggressively apply these specific legal shields to block incoming threats. When an employee reports a work-related stress complaint, you must file it strictly as an incident-only record. You must avoid the reporting trap at all costs. Do not, under any circumstances, authorize medical treatment for these initial complaints. If you pay for even a single therapy session out of pocket, you implicitly authorize the validity of the entire claim, opening the financial floodgates before the state even reviews the case. Agents, you need to immediately audit your client's disciplinary logs and supervisor communication scripts to ensure the personnel shield remains completely intact. Employers, you can access the required tools to take control of your costs and secure your operations at lockedandloadedtraining.com. Professional stewardship requires an active, rigid defense. Mastering these new rules is the only reliable way to prevent standard industry inertia from slowly draining your business.